Okay, to everybody out there, it is a lot more comforting when I can look over a podium and see the audience and gauge whether or not everybody can hear me and is participating. But I cannot see you all, so I'm going to hope that everybody is set up and ready to go. And then I would say good morning and welcome. Thank you for joining us for our Virtual Estate Planners Day 2020. As many of you know, we had to reschedule this event due to COVID-19. And on that note, I hope everybody is doing well and has found some way to normalize both their personal and business lives in at least relatively in this very difficult time. So today, I guess, would be the 198th day of March, the way I see it and the way it feels to many of us. It's also the 473rd day then of our fiscal year ending in May 31st, hence the 2018-19 fiscal year Estate Planners Day that hopefully you will all enjoy. We're very excited and grateful that you're joining us today. We have a great lineup for everybody today, filled with 7 relevant sessions on estate planning, tax, trust, valuation, and more. Before we get into the session today, I'd like to mention a few things. First, thank you to the outgoing and incoming board of directors of the council. Without them, none of this would occur. Similarly, for today's event, I would like to thank the Estate Planners Day Committee. I won't mention all the names, but chairs Mark Martiak and Pat Raffinelli, thank you for your help. Without them, and of course the board, many of whom participated on that committee, without these two groups of people, we would not have such an engaging day planned for you all today. We'd also like to thank our sponsors for this event. Thank you to our headlining sponsor, BNY Mellon, our exhibitors, Doyle, Bonhams, Inspire, MPI, SunTrust Private Wealth, our partner sponsors, Northern Trust and AltaView Advisors, and our associate sponsors, Appraisers Association and the American Cancer Society, Heritage Auctions, and Grassi. We very much appreciate your support of the council, and please be sure to visit please be sure to visit all of the exhibitors and sponsors during the breaks today and during our networking hours from 5 to 6. You will find the exhibitors and sponsors tabs at the top of your screen in the blue bar. I encourage you all to at least take a look around. They should have somewhat robust exhibitor halls, virtual exhibitor halls. And then, of course, to join us today, hopefully, during our networking hour from 5 to 6 p.m. Regarding our continuing education credits, we will be offering CPE, CLE, CTFA, LA, and CFP credits for Estate Planners Day. During our session, you will hear 2 codes given verbally. If you wish to apply for CE credits, please record these codes on the attendance verification form you received for each session. Of course, if you haven't printed them down, make a note of them somewhere so that you can complete that form after the fact. Completed verification forms should be submitted to epcnyc@caphill.com by September 23rd. Again, that's our general mailbox, epcnyc@caphill.com, spelled CAPHILL.com. You should all have that information. We have been approved for 8.75 CTFA credits, 8 CFP credits, and 4 LA credits for insurance. CLE credits are currently pending for the program, including 1 diversity CLE. With that, I hope everybody's got that. Be sure to listen for the 2 codes during each session to get your credits. Now I'd like to turn it over to our first panel of the day and welcome Rosie Shum, who will be introducing and moderating the panel. Thank you all.
Thank you so much, David. Good morning, everybody. I'm from England. I'm a London-based family lawyer, and I'm here to introduce the first session, Prenups, Estate Planning and International Considerations, how to get them right from the outset at today's event. A few housekeeping matters. I know David has already touched upon them, but I'd like to also give thanks to our sponsors. Thank you to BNY, Bonhams, Spear, MPI, SunTrust Private Wealth, Northern Trust, AltaView Advisors, Appraisers Association, American Cancer Society, Heritage Auctions, and Grassi. Thank you very much for your support. Please be sure, as David has already said, to visit our exhibitors during the break and at the end of the day. Some other announcements for today's session. All attendees are muted. Please use the chat feature to ask questions, which we will address at the end of the session. All sessions are being recorded. Attendees will have access to the recordings and the slides in the conference platform for 1 year, for one whole year. We'll be offering CPE, CLE, CTFA, LA, and CFP credits for Estate Planners Day. During the session, as David has already said, you'll hear 2 codes, which I will give verbally. If you wish to apply for CE credits, please record these codes on the attendance verification form you received. Submit completed verification forms by September the 23rd, 2020 to receive credits. I'd now like to introduce our speakers for today's session. Sean Weisbart from Blank Rome LLP. Sean Weisbart concentrates his practice in the areas of trust and estates law and tax-exempt organizations. His trusts and estates practice is focused on domestic and international estate planning, the administration of trusts and estates, and the representation of beneficiaries and fiduciaries in contested matters. He also advises clients on the preparation of pre- and post-nuptial agreements, which is the focus of today's talk, and the modification of trusts upon divorce. Quite impressively, Sean serves as an adjunct professor of law at both the New York University School of Law, where he teaches income taxation of trust and estates and international estate planning, and Fordham University School of Law, where he teaches trusts and estates drafting. Sean is a fellow of the American College of Trust and Estates Council. He also serves on the boards of various philanthropic organizations, including as general counsel on the Mentor Bocuse d'Or, a biannual culinary competition in France, and as chair of the Next Gen Trusts and Estates Committee of the UJA Federation of New York. Moving on to Evan Shine, who's an experienced matrimonial litigator, having litigated matrimonial matters in the Supreme and Family Courts of Manhattan, Kings, Queens, Nassau, Suffolk, and Rockland counties. And he's also worked extensively practicing in the courts of Westchester County. His practice also focuses on representing professional athletes in family law matters. As prior to becoming an attorney, he was a sports agent. He has now blended his 2 passions of sports and family law to create a really unique practice of sports-oriented family law. Evan has been recognized in the New York Metro Super Lawyers edition from 2013 to 2019. He sits on the faculty of the New York College of Matrimonial Trial Attorneys and has been cited in publications for his work on prominent New York family cases. He's achieved the top rating of 10 at AVO, the prominent attorney ranking database. In 2019, he was selected for inclusion in Westchester Business Council's prestigious 40 Under 40 list. And I'm Rosie Shum, a London-based family lawyer specializing in high net worth clients on complex finances and divorce cases, including those relating to children. My work frequently has an international dimension involving trusts, offshore assets, and family businesses. I'm also experienced in preparing and negotiating pre- and post-nuptial agreements for international families, particularly with a UK-US emphasis. So an introduction to the objectives of today's talk. Our first objective is to increase the awareness and understanding of the components of prenups. Our second objective is to share the best practice in preparing and negotiating prenups. Our third objective is to raise understanding of cross-border and multi-jurisdictional issues. And our fourth objective is to promote collaborative methods to deliver and achieve the best results for our clients. Prenups have an increasingly important role to play in estate planning, and family and trust lawyers need to be more estate issues with. We are more aware than ever of the need for nuptial agreements to work across jurisdictions. The COVID-19 pandemic has heightened some immediate issues and concerns surrounding prenups, as weddings are postponed or moved abroad, and couples' finances are hit by market volatility. I have found from my own practice that there has been a bottleneck of prenup work in the late summer, early autumn, as the usual wedding season has been delayed. I start with our first question. What are the essential elements when drafting a prenup? Specifically, how do you address the trust issue and providing full financial disclosure? I'm going to turn to Evan first to answer that question. Evan.
Morning, everyone, and Rosie, thank you for the fantastic introduction. It's great to be with everyone virtually this morning. So I want to start by saying 50 years ago or so, prenuptial agreements, they were relatively rare. People started living longer, family dynamics became complex, they became entangled. And back in the day, when in a family, somebody would pass away, there were kids, somebody would move away and potentially get remarried. There was a concern by the kids that the new spouse would come in and look to grab the remaining estate. Now, prenuptial agreements are common, and in many situations, they're expected. Now, before even getting into the essential elements, as Rosie mentioned, it's imperative that a client, regardless if you represent the more moneyed spouse or the less moneyed spouse, understands what a prenuptial agreement is really about in the first place. And by this, I mean, by its very nature, a prenuptial agreement takes away the rights conferred upon a spouse by the state that spouse will have under the law in the event of divorce or death. And with a prenuptial agreement, you're substituting your own judgment and you're coming to your own agreement. Now, diving into the essential elements. Now, the first is division of property, which in the state of New York is called and referred to as equitable distribution. And I do want to note that New York is not an equal state. It's not a 50-50 state. New York is an equitable state. Now, this has a couple of aspects to it. First, what is marital property and what is separate property? And to me, this is the foundation of any prenuptial agreement. How do you define marital property and how do you define separate property? And after you define it in a prenuptial agreement, the question is, how do you divide it? Now, under a prenuptial agreement, you define what's marital and you define what's separate on your own. Now, you may have nothing that's marital and all property may be separate, but the point is that clients control how they define what's separate and how they define what's marital, not the state and not the domestic relations law. And again, one person may be giving up substantial rights, so it's important for the client to understand what those rights are. For example, in New York, once a divorce action is commenced, you cannot force someone to leave the marital residence unless there's a safety concern or the threat of physical violence. In a prenuptial agreement, you can change that. Parties can come to their own agreement. They can put forth and specify a timeline or certain events, trigger events, force someone to leave someone's separate property based on different criteria established in the prenuptial agreement. Spousal support. Now, the guidelines in New York for alimony, spousal support, they provide us with a measuring stick, both in terms of the duration of spousal support as well as the amount of support. Now, a prenuptial agreement could essentially take away all those rights, or the prenuptial agreement can include spousal support subject to whatever limitations the parties themselves can agree to. Now, I want to touch on child support and child custody. In the state of New York, you cannot provide for custody or child support in a way that's enforceable down the road in the event of a challenge. Now, I find that some attorneys do it anyway, and we'll touch on that in the pitfall question, and some attorneys do it as a demonstration of intent, but in my opinion, I find it totally meaningless. I want to touch on financial disclosure. Financial disclosure is an absolute key to enforceability down the road of a prenuptial agreement. Financial disclosure must be complete, it must be detailed, it must be thorough. I always recommend being overly inclusive and leaving absolutely no stone unturned when it comes to disclosure of income and assets. Specifically with trusts, I like to provide trust documents, financial documents. There may be a confidentiality agreement that goes along with it, as well as providing a description of the trust as part of the disclosure. Estate rights are also part of a prenuptial agreement. If one spouse dies while married, how we're going to treat that. And for that, I know Sean's going to weigh in much more detail.
Super. Thank you very much, Evan. Should provide.
So thank you, Rosie, and thank you, Evan. It's great to be with both of you, and it's so nice to see so many familiar names on the participant list. So hello to all of my friends and colleagues out there. Wish we could be together and look forward to that day. I'm going to speak right now about the estate elements of a prenuptial agreement, and then talk more about disclosure with respect to trust agreements. So estate rights in a prenuptial agreement, most of us are probably familiar with the two rights that a surviving spouse has at death. That's the right of election when there is a will, and then of course the right to intestate distribution if the first spouse to die dies without a will. There's also the right, of course, to a homestead, which I think includes farm equipment and a car, but that's probably less relevant in New York. Although maybe it's relevant, but effectively in a prenuptial agreement, spouses can waive full estate rights to all of the rights that a surviving spouse would have at death. What this would do would mean that when the first spouse dies, they are absolutely free to dispose of their wealth however they see fit, and the surviving spouse would have no right to elect against the estate if they die without a will, to intestate distribution, to serve potentially as a fiduciary, etc. That doesn't mean that the first spouse to die would be prohibited from making distributions to a surviving spouse, but by definition, there would be no obligation for the first spouse to die to do so, and no rights that the surviving spouse would have to compel. Now, what are the common ways this is handled? There could be absolutely no estate waivers at all. The focus of the agreement may be on what happens on rights of dissolution, and they leave all estate rights intact. It is also quite common to have estate rights waived with respect to each spouse's separate property. So the surviving spouse, whoever that will be, would waive right of election on separate property, but there would be no waiver with respect to marital property. That's quite common. And it's also quite common to perhaps waive rights, whether all rights or just rights with respect to separate property, for a period of years, and to have that provision sunset after a certain duration of the marriage. So if the marriage has lasted more than 20 years, full estate rights exist. Now, how do you compensate the other spouse for the waiver of estate rights? If both spouses are fully comfortable with this provision, there may be absolutely no compensation. There just may be a full mutual waiver. If that's the agreement, that's perfectly fine. Sometimes, and I see it especially in second marriages, where one spouse may have considerable more means than the other spouse, and as Evan alluded to, maybe the genesis of prenups was in this situation, that the moneyed spouse would say, I want a full waiver because I want my wealth to go to my children. But the less moneyed spouse may say, look, I'm going to be married to you for 20 years potentially, and I understand it. You have kids from a prior relationship. But I want to know that I'm not going to devote the rest of my life to this marriage and be left with nothing. And so life insurance is a very common way that we will see the non-moneyed spouse compensated for a waiver of estate rights. So effectively, for waiving the right of election, the non-moneyed spouse would receive a guaranteed minimum of X number of dollars that could be satisfied through life insurance. That's quite common. Other issues that come up with estate rights are portability. And I think this is something that's missed sometimes in many agreements that I've seen. Portability, of course, is the concept for estate tax purposes that the surviving spouse will inherit the unused exemption amount of the first spouse to die. But to make a portability election, the executor of the first spouse to die has to affirmatively do so. And so it's important to include in a prenuptial agreement an obligation for the first spouse's estate to make that portability election so that the surviving spouse is able to receive that guaranteed. Potentially, if the first spouse appoints their child who has animosity towards the surviving spouse, that could potentially be an issue. Let me move on to talk more about disclosure. Evan already mentioned the significance of disclosure, and I want to focus specifically on trusts. And I want to talk about it both for the moneyed spouse and the non-moneyed spouse. Trusts are a very interesting issue in divorce litigation, in the sense that trust assets, irrevocable trust assets, are generally not marital property or separate property. They're the property of the trust. But that doesn't mean that a spouse cannot assert rights or make various claims to trust assets based on potential facts, how the trust was administered during the marriage, whether a trust was created in close proximity to commencement of a divorce action, and a number of other factors. And so given this possibility, it's important that the spouse who's a beneficiary of the trust, or maybe even created a trust prior to marriage, it has full disclosure of what those trust assets are, not only of the existence of the trust, but what the underlying assets are. And that they enable the other spouse to ask questions, to review records. They provide full disclosure so that if the other spouse is waiving those rights to the trust assets, there's full disclosure and that won't be an issue. For the non-beneficiary spouse, it's equally important to understand what the assets of the trust are so you understand what you're really waiving. And it's a funny thing because to some extent, if the assets of the trust are not necessarily marital property anyway, but nonetheless, they might be marital property if they weren't owned by a trust. And so you should really understand what you're getting into. And I think business interests are really the key thing. Imagine someone transferred their business to a trust, and if they were going to do so, they would likely transfer it to a trust that was not settled under New York law, but probably an asset protection trust settled under the laws of Nevada, Delaware, South Dakota, Alaska, or the other 16 states that have asset protection trust laws. By doing so, they're attempting to shelter the appreciation earned on the business from equitable division by the concept of the fact that now this business interest is no longer their property, right? Therefore, it's property of the trust. And so the non-beneficiary spouse who doesn't own the business would have no rights to it. The reason I'm mentioning this is in a business, the business interest itself, if it's owned prior to marriage, would be that spouse's separate property, but the appreciation on the business during the marriage would be marital property. And so if the business is transferred to a trust, the other spouse would effectively be missing out on their rights to share in that appreciation. And so it's important, if you're waiving your rights to the other spouse's trust and it owns a business interest, you're understanding that you're waiving your rights to that appreciation, which could be very substantial, and you may want to ask for the appropriate compensation for waiving those rights.
Thank you very much, Sean. That's very, very helpful. I'm just going to give you a bit of insight from across the pond. From an English law perspective, prenups are not automatically enforceable. The English court disclosure. You have to know what you're signing up to and giving away. You also have to make sure that you're both independently represented. You can't be represented by the same lawyer. You have to really understand what you're signing up to, what you're giving away. That's absolutely fundamental. But most importantly, in England, the English courts, the English judges retain a discretion to determine whether the agreement is fair in the circumstances at the time that the parties divorce. And that's why there's a problem. There lies the rub. Because obviously what's fair, perhaps when the parties get married, isn't necessarily going to be fair in 15 years' time when they've had 4 children and are living in a much bigger house than they were once living in. So it's our job as family lawyers in the UK to make sure that our agreements weather with time, that they endure these changes to the parties' lives. It's not considered to be a good idea to put in loads of review clauses, which will mean the parties have to visit you every few years, but it is a good idea to make sure that we've met each party's reasonable housing needs and reasonable income needs. And that's why in our prenups, if you ever get a chance to look at them, they're very, very specific in terms of the definition of reasonable housing needs and reasonable income needs. And there lies the rub. Moving on very quickly to the issue of trust disclosure. Over disclose, over disclose, over disclose, because that will protect those assets from a UK perspective. I think Evan and Sean, you've also articulated this to me as well, that it's always better to put some quantum in there to protect the asset in question. And I think that's definitely what I would normally advise, but bear in mind that the English courts, again, can invade pre-acquired or inherited assets on the basis of meeting the parties' needs. And they can actually vary trust under Section 24 of the Matrimonial Causes Act. And that's a real issue. And it's a real anathema sometimes to American lawyers that I'm often working with on prenuptial agreements or postnuptial agreements, the idea that English courts can actually make orders to vary trusts. And absolutely, as you said, Sean, it's all about the way that the trust was actually dealt with during the marriage. How was income received by the parties? How was it treated? Was there a continuous income? There's case law to show that if there's a continuous income, it demonstrates that really this trust has been a resource for the parties capable of being varied. Okay, moving on to the next question. What are the pitfalls when preparing prenuptial agreements? I'm going to come to Sean first on this one. And what should we avoid?
So as Rosie, Evan, and I already mentioned, disclosure is so important. And I want to talk specifically about trust disclosure. You should not only disclose the existence of the trust and the nature of the beneficial interest in the trust, but you want to disclose the trust assets for the reasons I already mentioned. But also think about if during the marriage, there's going to be a distribution from the trust, okay? And if subsequently there's a divorce action, it's very helpful to have disclosed what the assets are, particularly if the trust holds potentially unique assets, so that therefore you can trace what those assets are, so that it's easier for the beneficiary spouse to make sure that they retain that without any claim by the other spouse as their separate property. So that's very important. Trust in general, I already spoke about, but it's very, very important to be mindful of trust and think about the jurisdiction of the trust. There are so many cases out there. It's, I think, a very, very hot issue in the context of both family law and trust and estates, is how trusts are treated in divorce actions, in prenuptial agreements, and specifically with the popularity of asset protection trusts. We know in New York that a trust that is created by the settlor or grantor is not entitled to any asset protection if the creator is also a beneficiary of that trust. But that is not the law in 20 other states. And so you have to be very watchful, both in a prenuptial agreement and even during a marriage, about how assets owned by such a self-settled trust that's owned outside of New York will be treated. And it's probably important to maybe think about that in a prenuptial agreement, and to maybe keep out a self-settled trust as separate property that should potentially be marital property. Self-settled trust funded with marital property during the marriage. That's an important thing. Let me move on to the third pitfall, which I think is really meant for my T&E friends in the audience, is that a lot of times clients will come and they'll say, look, all I wanted to do was protect this one asset in case of divorce. Why am I signing a 40-page agreement? You know, this is ridiculous. I don't want to do that. And, you know, you'll say, okay, yeah, we don't need these provisions, no big deal. But actually, a lot of the provisions in a prenuptial agreement are very, very important and shouldn't be overlooked. And so I think the third pitfall I'm going to mention is don't overlook those provisions. Yes, your client may only want to do one thing, but housing, I think that there's, you know, maybe I don't know if it's a myth or not, but there's some myth out there that maybe it's easier to pull a fast one on a trust and estates lawyer. Maybe not me, but you know, so you want to be mindful of those provisions in a prenuptial agreement that even you or your client think, why is this necessary? I think housing is such a residence is such a key issue. And if you think about it, there could be pages in an agreement about what's going to happen to marital residences when they're sold, whether they're jointly titled, whether they're separately titled, when, who has to vacate and when, how will the sales price be determined, who the appraisers will be, when will the price be reduced, how will the carrying charges be paid between the time of commencement of a divorce action and the adjudication or the sale of the residence. All of those things are actually enormously important and should not be overlooked at all. Because if you think about it, everyone's in love at the time they're signing the agreement. But you know, there are terrible divorces. That's not a myth by any means. And if you have two spouses fighting over, I want the house to be sold for this, I want the house to be sold for that, you pay for this, I don't agree with this appraiser, you are going to delay the sale of the asset. You're going to make the divorce that much harder. And so I think a pitfall probably for many T&E lawyers, because we in our practice, right, in our estate planning practice, we don't deal with these issues. We deal with estate planning, we get the concept of separate and marital property, but some of these other provisions are not things that the T&E lawyers see day in and day out, even though family lawyers do. But they're in the agreements for a reason, and they're very important to be there and should not be overlooked and should not just be given into blindly by you or the client that you're representing, particularly if you're going up against a family lawyer.
Definitely. Thank you so much, Sean. Now, moving on to Evan, what do you think the pitfalls are and what should we avoid?
Rosie, thank you. And Sean, you bring up some really great points. I have 5 quick pitfalls that I want to quickly run through. Pitfall 1, from the family law perspective. As an attorney, don't just throw a lot of stuff in there, right? You know, clients come to us all the time, and, you know, clients may say, I want an infidelity clause in the agreement. I would like to address child support in the agreement. I would like to address child custody in the agreement. Don't just put these things into an agreement because your client wants these things in an agreement, right? Explain to your client that down the road, if there's an enforceability, you know, issue, or there's a contest or a challenge, there is likely to be a problem. And these clauses in the language that a client may want in the agreement will likely not be upheld down the road if there's a challenge. Pitfall 2, and both Rosie and Sean, you know, touched on it. Each side should have independent counsel. It amazes me still that I see one attorney represent both people in connection with a prenuptial agreement. Each side needs to have their own independent counsel. Now, again, if there's a challenge to the prenuptial agreement down the road, one of the first questions a judge or a court is going to ask is, was each side represented by counsel? Was the agreement negotiated? What was the process? Was it reasonable and was it fair? Pitfall number 3, avoid conflicting paragraphs and make sure that the definitions of separate property and marital property are read and understood and that they don't conflict with one another. As I mentioned, you know, earlier, I find that, you know, the foundation of a prenuptial agreement is really how you define separate property and marital property and the agreements that people come to on their own. A pitfall and something to avoid, when you're referring to marital property, don't use the word joint to refer to marital property. It has an entirely different meaning than marital property, which under the domestic relations law is how property is defined. Marital property and separate property. I see far too often property being referred to as joint, and it causes tremendous confusion down the road. Pitfall 4, avoid signing the agreement in the shadow of the altar. And what I mean by that is, in New York, there's no time frame, there's no, you know, steadfast rule that the agreement needs to be signed X amount of months, weeks, or days prior to the wedding day. But good practice is have the agreement signed enough in advance. Right? You know, far too often I see agreements being signed the night before the wedding when people are, believe it or not, in the middle of their rehearsal dinner. You know, when people are, running around making last minute wedding plans, avoid it, right? Good practice if you can control it. And sometimes, again, clients come to us at the last minute and they want agreements done, but best practice would be to have the agreement negotiated, prepared, reviewed, understood by both parties far enough in advance. And the last pitfall, and again, we've touched on it and we'll continue to touch on it because it is super important. Avoid incomplete, quick financial disclosure because that's what the client wants. Again, if there's a challenge down the road, a judge is going to look at the extent of the financial disclosure. Was it complete? Was it accurate? You do not want to leave the door open for a potential challenge where somebody says, we had no idea what this person was worth. We had no idea the amount of someone's wealth and assets. And this brings up the point of working with a team of professionals, whether it's a trust and estates attorney like Sean, whether it's CPA, whether it's a financial advisor. I can't stress enough how important it is when you're working with a client in connection with a prenuptial agreement, and there's businesses and there's trust and there's substantial assets, to surround yourself as a family law attorney and your client with an excellent team of professionals who could advise and help everybody truly understand the true extent of a client's wealth and assets.
Thank you very much, Evan. I just want to add. It's very important. Okay, perspective. If it is signed within the 28-day window, it's not fatal. But it does mean that you probably should sign a confirmatory deed or a postnup 6 or 8 weeks after the wedding. It's something that comes up a lot. Essentially, it's there from an English perspective to protect against allegations of undue influence or duress. Because obviously, if a party hasn't had enough time to consider the agreement, they may say, I didn't know what I was signing up to. And so it's very important from an English perspective that you bear that in mind and we give ourselves a good lead-in time. I think ideally we'd be getting these things signed months before the wedding, but of course then it does mean you do have to update the financial disclosure schedules, which can sometimes be a bit of a pain. The other point I think has already been touched upon by Evan, and that's about detailing, making sure your descriptions of assets are absolutely accurate. The distinction between marital and separate property from a UK perspective is exactly the same. It's just as imperative that you make sure that those definitions are clear and there's no confusion built into those definitions. So it's the precision with which you draft them, which is why you need that expertise. And the final point that I wanted to make was really making sure that you do some crystal ball gazing, looking at what's fair in 5, 10, and 15 years' time from a UK perspective, so that we're really looking at how this marriage might work, how the household expenses are going to be paid, what's going to happen to the children in terms of their expenditure relating to them, private school fees, etc., but also how businesses and how they're going to be treated in circumstances of divorce. And so all of that needs to have really carefully been thought out and nuanced in the right ways in the drafting. So that's why you need experts to help you with the drafting from your own jurisdiction, but also cross-jurisdictional if there's issues from across the seas. Thank you very much. The next question is, again, across the seas, what cross-border issues need to be taken into account with the drafting of prenuptial agreements? I'm going to come to Evan first on this question. Evan.
Rosie, it's a great question. Anytime this is an issue in connection with a prenuptial agreement, I always say you choose jurisdiction based on where you're going to die or where you're going to get divorced. And cross-border issues are something that it has to be discussed at the outset when you're discussing your client's situation. If you know that your client is going to move, if your client is going to relocate, if you know that your client has dual residences or a business in another state, or let's say in London, it's something that absolutely must be addressed in an agreement and at the beginning. And in connection with a prenuptial agreement, you can determine jurisdiction in an agreement. In order to effectively do this, you need to know the laws of the jurisdiction. So for example, whether it's London, whether it's say a state like California, it's imperative that you work with other attorneys to seek advisory opinions as to the enforceability and the laws of that jurisdiction. Now, specifically with New York, a New York court, for example, let's say there's a prenuptial agreement in London. Rosie, comes to me and says, Evan, what is the likelihood of this agreement being enforced down the road? Here are certain provisions and language that we would include. Is there an advisory opinion? Could you advise us on the enforceability in connection with this agreement if there's a challenge or a divorce down the road? Now, generally speaking, a New York court would look to English law to determine the formal validity of the agreement. New York courts will generally accept a foreign acknowledgement of a marital agreement that's done in accordance with the laws of the place of execution and acknowledgement. And this is the certification of conformity. And this is something that should be done in connection with the agreement. And for example, there may be aspects that Rosie may look to include in an agreement, such as spousal support. And if you know that there may be, a jurisdictional issue down the road, there may be New York waivers with respect to spousal support. There may be New York waivers with respect to estate rights. There may be child support or child custody provisions that, let's say, another attorney would include, but would not be enforceable in New York. And it may be better to be silent than include certain provisions that, as a New York family law attorney, I know for a fact will not be upheld if there's a litigation, divorce, or if there's a challenge down the road.
Thank you very much, Evan. Sean, can you touch upon this issue?
Sure. So I think that in a prenuptial agreement, it's important to consider cross-border issues, meaning cross-border with the United States and other countries, but as also cross-border issues within the United States, because we have separate property states in the United States and community property states. And the laws regarding the dissolution, property upon dissolution and death in community property states and separate property states is wildly different. So it's important to keep that in mind, as well as the cross-border issues. On cross-border, Evan made the point that I fully agree with, that I would not generally include issues relating to custody or child support in an agreement. But I think in the cross-border context, this might be the one place where I might make an exception. And this would be in a situation where a couple is contemplating having children abroad and returning to the United States, or maybe has young children and is going to be moving abroad for a period of time. And in that case, although it's not enforceable, there's something called the Hague Convention. And I think based on that, I would at least include a provision of intent that the couple intends for the children to be raised in whichever jurisdiction that they want. Because otherwise, what could happen is if there's a divorce while the children are abroad and the intention is for them to be raised within the United States, not that it's a guarantee if you put it in the agreement, because you'd be relying on a foreign court to enforce that provision, they may not do so. But it's better, and I think it's smart in that situation to include provisions on children in that cross-border context. Another interesting issue with respect to estate rights that I think comes up with cross-border is particularly true when you have a client who has European citizenship as well as American citizenship, or potentially multiple citizenships within Europe. And that is based on the fairly recently enacted European Union succession regulations, also known as Brussels IV, that actually allows someone of dual citizenship to elect the whole law of a certain place, another place, to govern the distribution of their property at death. And that can effectively allow someone to opt out of community property rights. It can effectively allow someone to pick a jurisdiction that recognizes trusts, even though other jurisdictions do not recognize trusts. And so in the cross-border context, I think it's also very, very important to have these conversations. Of course, it's tough to predict, what's going to happen at death, but at least have these conversations about which law will apply, because the laws of when you have potentially two different countries may be wildly different.
Thank you very much, Sean. I think just touching upon the question of where to root has been issues come up on a number of prenups I've been drafting recently. And often couples live these peripatetic lives, particularly young couples working at big organizations like Facebook or Bloomberg. They're moving around the world and they can live anywhere they want to live. And if they come to me and they say, I want a prenup, an English prenup, I'll say, well, where are you going to be living in the first few years of your marriage? And we'll have to really analyze what their life will look like for the next sort of 5 years. And I've had this issue very, very recently where we've decided to root it in England, but at the same time, make sure that we're getting advice, obviously, in New York, because the couple are planning to move to New York within the next year. And it's just really important that you get a mirror agreement, potentially in New York, or that you get that advice to make sure it underpins the agreement. That's from a UK perspective. And obviously that's something that comes up a lot on prenups that I'm drafting at the moment, particularly given the global pandemic. I've got some couples who are marrying in England quickly, moving across to the US, and all sorts of just changing lives because of this pandemic, changing objectives because of the pandemic. They've decided they want to be in another country, they want to be living a different type of life. They perhaps want to be living in the country as opposed to a major city. And I think it's just something that I'm really cognizant of at the moment as an English practitioner. Moving on to our next question, if you don't mind, fellas, I'd like to amalgamate the next question with the next two questions together, because I think they work well together and we haven't got that much longer left. So the first question is, how do you broach the difficult subject of prenups with your clients? And the second question is, how do you successfully navigate the negotiations from a psychological perspective? So really this is a sort of psychological element of making sure we get our clients in the right place and we get the best results for our clients in the process. I'm going to start with Evan again on this one.
Rosie, thank you.
Can you hear me? Before you move on, I just noticed in the chat that we are to distribute the first code, and I know you guys are focused on the presentation, and the first code for this session is planning.
Super.
There you go. Continue.
Thank you. Super. Okay, Evan.
David, thank you. And Rosie, this is a great question. You know, my answer is, you know, the only way to, you know, broach the difficult subject of prenups, and look, it is a difficult topic. It is a difficult subject. People don't like talking about money, about finances, and people definitely don't like talking about prenuptial agreements. The only way to approach it is directly. You know, when I say that, it's, you know, I believe it's the attorney's job to make sure a client understands, again, regardless of who you represent, the moneyed spouse, the less moneyed spouse, that it is understood what a client is entering into and what a client is giving up. Because when it comes to prenuptial agreements, clients have a lot of risk. And I believe attorneys need to explain the laws. And I think it's much easier for lawyers to approach things directly with the client than for the clients themselves to approach things with one another. And I'm all for clients attempting to have a conversation as long as it stays in a place that both people are comfortable with. But if that conversation amongst clients devolves quickly, I always find it's helpful and easier and better when attorneys get involved. Now, with respect to the laws, equitable distribution laws in the state of New York, they're fuzzy, they're gray, and there's a lot of doubt. So one of the benefits of a prenuptial agreement is that you eliminate a lot of the doubt in the equitable distribution laws because you're coming to your own agreement. And when I have conversations with clients about entering a prenuptial agreement, it's not easy, you know, but if you approach it directly and you help a client understand the purpose of the agreement, the intent of the agreement, and the goal, I think it definitely, you know, helps the conversation and the negotiation. And look, the reality is, you know, relationships, you know, they're like the weather, right? You know, they change, marriages change, relationships change. And, you know, I think it's important for clients to understand that there may be a reason to enter into an agreement. The other thing I would say is, you know, you can tell a lot about the person you're about to marry from the discussion about a prenuptial agreement. You're going to find out a lot about what may be important to somebody, how somebody reacts, you know, and it's a very interesting, you know, discussion, negotiation, you know, because when you think about it, the basic message, you know, is any way you want to spin it is, I love you. I can't wait to spend the rest of my life with you. And at the same time, I may not fully trust you. And so there's also an emotional component that is real that I think attorneys need to understand when they're negotiating and broaching the topic of prenuptial agreements with their clients.
Thank you so much for the insights there. Now, Sean, can you add anything further to that?
Absolutely. First of all, I think maybe it's a libertarian streak in some people, but if you look at DRL 236B, which governs the division of property upon dissolution and maintenance, etc., it's filled with references to the fact that the parties can have their own agreement and deviate from these rules. And so, it's perfectly reasonable for two people getting married to want to say, you know what, we don't like what these arbitrary potential rules, I'm not saying I think they're bad, in New York will create, but actually the law is very unclear because, equitable division is based on totality of a number of different factors, and maintenance can also consider that, especially over the cap. And so, having an agreement is actually allowed by statute. So it's in New York, and they're very well respected. And so that's one thing to keep in mind. The other thing to keep in mind in an agreement is that it may very well enable someone to share more in the marriage than if they did not have the agreement. Because once you get married, the intention very well may be to title assets jointly, to treat yourselves as a single economic unit. But if you're going to do so without an agreement, and you start commingling assets, you may not get the substantial assets that you had prior to the marriage back. And so the agreement, by giving something called separate property credits in various different situations, may enable you to blend the assets more together in a way that you're comfortable. Whereas if you otherwise relied on the law, you might just be keeping everything separate, and that wouldn't be good for the marriage either. It wouldn't be how you want to have a life with that person. The other thing that I always encourage clients to do is to be fair. I can't tell you that clients always listen to me. They certainly do not. But I always, point out when I think a client comes to me and has an unreasonable position that I think, look, you want to protect this asset. This is what you've got to give for it to be fair. We can try for something else. Some clients want that. Other clients are very happy to have that advice. And, I think when two people are being fair and understanding of, I want to protect this asset, but I'm compensating you in this way, the negotiation is perfectly reasonable. The other big issue that I think can come up in making the negotiation reasonable is who's on the other side. As Evan mentioned, in New York, it's very, very important, and Rosie said it, critical in the UK, to have two lawyers, one lawyer for each spouse. And who the lawyer is on the other side, I think, is a critical component of how the negotiation is going to go. Look, if you can get your spouse to a lawyer who doesn't know what they're doing and they bless it, I mean, God bless you, okay? If that's what you want to do. But otherwise, you want to go to someone who's intelligent, who knows what they're doing, who's a reasonable person, who's not going to instigate fights and make it a long, drawn-out process, but also is someone who understands the issue so that they can negotiate from a fair place and not come back with ridiculous demands on the other side, but point out, hey, you're asking, this is something you're asking for, so I want this in return, and that's reasonable. So I think that's it. And then on the other side, I mean, sort of the interesting thing on prenups is that I get to represent clients on both sides. So not that I'm two-faced, but you kind of, have your phone call at 1 o'clock and be, yeah, well, we'll get this for you. And your phone call at 2 can be like, we got to protect you. So you have to do both sides. So, when you're representing the client who you're protecting, it's very important that you convey to the other side, look, I'm willing to allow you to keep this for yourself, to protect this. And, if it's not a big deal, fine. But if it's something that is really going to affect rights on dissolution, then I think, or death, then you've got to be willing to ask and point out, have a good lawyer who points out, yes, we'll allow you to do this, but we want to be compensated in this way. What that does is it creates fairness, but it also creates certainty. And I will point out, I think one of the interesting things when I'm especially representing men, and I know it's 2020, so gender normativity is certainly out the door, but it is something I see. Men who are going to marry a woman with a wealthy family, and the wealthy family is pushing the agreement, and they want to require their future son-in-law to waive rights to the family business. And the son-in-law says, "Oh, of course, no big deal. It's, you know, it's the wife's family's business. What do I want? And I have no rights to it." But then they end up working for the family business. The wife has massive appreciation on the family business, and they've waived all of that. And then in the worst case scenario, they get divorced. They're working for the family business. They're out of a job, and they're out of the marital component of the appreciation on the family business. I think that happens quite a bit. And that's something I think you've got to really keep in mind, understanding what you're waiving and being fair. And it's critical to educate your clients so that they know what they're giving up, what they're asking the other spouse to give up. And, you know, I always believe if people are being fair, these things are as easy as they can be.
And Sean, I just want to piggyback on something you said, because I think it's such a great point about knowing who is on the other side tells you a lot about how the process is going to go. The reality is the issues that are being negotiated in a prenuptial agreement are the same issues that are negotiated in a divorce litigation or a divorce proceeding. But the approach must be entirely different. And far too often, the approach by a lot of attorneys is not different. And as I'm sure you see, and Rosie, you see as well, that adds to the stress, that adds to confusion, and ultimately it ends up taking what should be sometimes a relatively straightforward process and agreement. You add, when you have attorneys on the other side who approach the prenuptial process like it's a divorce process, it creates, it's absolute chaos. The other thing that I just want to quickly point out, for a lot of people, the prenuptial conversation may be the first time someone is learning the extent of someone else's wealth and assets. And the other point is, it may be the first time that both people are learning the true extent of a family's wealth and assets. And it's important to understand those dynamics and how that will permeate the negotiation.
And if I could add one more thing that I think is interesting and a growing trend in estate practice that actually would probably make the prenuptial agreement conversation easier, is I'm seeing a growing trend in clients when we're doing wills and trusts, that they'll put a requirement that prior to the distribution at death to their child, if there's a trust, for the trustee to be eligible to make a distribution from that trust created at death to their child, that the child, if they're married, has to have a marital agreement, so either a prenuptial agreement or a postnuptial agreement, that sets forth certain requirements with respect to that property. And so, if it's really if the agreement is arising in the context of a parent who's going to want their child to have that agreement before they get married, having that in a will or a trust can certainly make the agreement easier, because the child can then just blame mom and dad and not blame themselves for potentially wanting the agreement. So that's, I think, an interesting trend in this area, and maybe a way in certain cases at least to shift the blame. That's always good. It's always good to blame your mom and dad in your 20s and 30s or even later.
Or even the trustees. You can blame the trustees.
Yeah.
They told me I have to do this. All my brothers and sisters, I have to get on and do it. I just love, so reassuring to hear that you have the same difficulties that we have. You have the strengths and weaknesses that we have in England. It's really reassuring to hear that. I think I love it. I have a nice dynamic construct. Really have a proper negotiation with me. Maybe I can predict some of the points they're going to put forward, some of the points they're going to give away, because it's better, isn't it, to include lots of points, but knowing which ones you're going to concede at the beginning and which ones you're going to hold on to. I think that's also important, and preparing your clients psychologically for that is really important as well. So I think for me, drawing up heads of agreement, getting clients to drip feed that information at home as far as they can, and getting them ready for the negotiations with the lawyers, so it's not fisticuffs, so it's not two Rottweilers facing each other. Absolutely, as you've said, Evan, and as you said, Sean, I want a nice, healthy, constructive dialogue, because ultimately these agreements can reinforce a marriage. Gone are the days that you don't know about your spouse's assets and you blindly go on being a homemaker and not working, looking after babies and not knowing what husband has in his bank account. Gone are those days. We're now on a much more level playing field in this egalitarian world where couples should have visibility of what they're entering into. And the transparency, in my view, can underpin a marriage. And I don't know if Evan and Sean, you have any views on that also.
Yeah, no, and Rosie, you make a great point. The thing that I would say is, for a lot of, couples that I work with, the prenuptial conversation ends up being a relationship strengthening, moment. Obviously talking about money, talking about finances, talking about difficult things, assets, expectations. It's not easy and it's challenging. And again, as I mentioned, you can learn a lot about yourself, a lot about your, soon-to-be spouse in this process. And I do think there's a relationship strengthening moment that if you can come out of this and, you now have the ability to discuss important issues such as finances, assets, expectations, and you have a true understanding, of the finances. I think it's, only, positive, going forward for a couple.
Yeah, indeed. And, obviously there's nothing romantic about, equating a future upcoming marriage with a business. But if you think about it, when two people are entering into a business together, they want to know what's going to happen if that business dissolves. And, if you can broach this subject by saying, look, we love each other. We want to be with each other. Our intention is to be with each other forever. But we know the law has certain rights, and it's important to know that, God forbid, this unexpected thing will happen. What will those rights be? And having a discussion about that at the outset before you just go ahead and go to City Hall and get married is maybe mature, I think. And if you both approach it from a level head and you're fairness, very important, I think that it's okay, and certainly probably the start of a healthy marriage where, like Rosie, you mentioned, it's not going back to the 1950s where the husband made all this money and the wife had no clue. And, the prenuptial agreement in a way is a start to understanding what the finances are of this couple.
And Sean, that's such a great point, and it's one of the things that, although there's no time frame, in New York, in order to have that intelligent conversation, in order to have that discussion, this goes back to why the process of negotiating a prenup, having that conversation, it's one that clients, attorneys, it has to start early. Because if somebody will come to me, Rosie, yourself, Sean, they're getting married in a month, it makes it extremely difficult to have these conversations. We're talking about pitfalls, things to avoid, how to broach the topic of a prenuptial agreement. It makes everything we're talking about extremely difficult if there's not proper thought and proper planning to the process.
Super. I've got a CE code to give you, which is okay, moving on to the final question, which is all about collaboration. How do we as family attorneys and estate attorneys work better together to achieve the best results for our clients? I'm going to start with Sean here.
So, the prenuptial agreement itself is really the perfect example of an interdisciplinary approach between trust and estates law and family law. And family lawyers day in and day out are seeing what the issues are that can come up on a divorce. Trust and estates lawyers are not. Trust and estates lawyers day in, day out see what happens when someone dies and a surviving spouse asserts certain rights or they're not adequately provided for. Family lawyers do not. And not to say that you always necessarily need both on every agreement. I mean, I'm not advocating to jack up fees for anyone, but when there are difficult issues that come up, if a T&E lawyer is doing an agreement and there are, unusual issues that come up in the context of dissolution, it would be very smart to have that agreement shared with a family lawyer. Or even just to have a family lawyer who you work with regularly, and this can be a good way of doing business development even for yourself, to have them spend an hour doing a peer review, just to make sure you haven't missed anything, anything maybe that's new in the practice, right? A new case that may have come up, various different things that you're not encountering every day. And then of course, you know, the reciprocal thing applies as well. If it's a family lawyer who's being, you know, the first chair, so to speak, for the client, and there's difficult issues in the estate provision, you know, I see agreements that have been drafted by family lawyers, and I see estate provisions where I would say, you know what, I think this could be a little bit more clear, or there's something new that comes up, and I think it would be wise. It's really a great opportunity to do it. And, you know, I'm at a firm where we have both, which is unusual. But for people that are not, it's a good opportunity to reach across, you know, call someone, especially a lot of T&E firms or practices are so small. Family law firms, for the most part, also are small. It's a good way to generate business by working with people and developing good relationships. And it definitely can be very, very valuable for the client.
Super. Thanks very much. Evan, how can we better work together?
Well, I think Sean makes some absolutely fantastic points. And, you know, the one thing I want to say is, you know, when there's difficult issues that involve estate planning and trust, I wish collaboration, it wouldn't be optional, because it really, you know, your client would benefit, whether you're an estate planning attorney or a family law attorney. You would benefit by working with a team of professionals to make sure that the language is correct, to anticipate, you know, what if there was no prenup or we didn't address certain issues? What would be the consequences to clients down the road in the event of a divorce when it comes to trust, as Sean mentioned in the beginning of the presentation? A lot of times people, you know, will come in and say, you know, look, instead of leaving, you know, my spouse, you know, a third, you know, how about we leave a certain percentage, right? 15%, 20%. Well, what does that really mean? Is it after expenses are paid? Is it after property is divided? Is it after, you know, certain equity is divided? How do we address certain issues that may come up in the context of the need to set up a trust, and really get into great specificity from a language standpoint to make sure that there's no conflicting paragraphs or contradictory language in the future if there's a challenge or a divorce. And I think if you can anticipate these issues, and as Sean said, you know, reach out to colleagues, other professionals, whether it's, you know, a quick phone call or it's bringing someone on board to really make sure that the language is crafted in a way that truly protects your client. I mean, to me, that's best practice. Especially when you're talking about businesses and trust and partnership. And, you know, even if there's an international component, you know, it's when you're looking to draft the perfect prenup for a client, which, look, all of us strive to do, you know, in order to do that effectively, when there's complex, you know, a complex financial structure and different layers of wealth in a business, it's imperative that you work with other professionals.
Super. Thank you so much, Evan. We've got 1 minute left, and in that 1 minute, we've got one question for David Weinstock. In what circumstances?
Before you do,
yeah,
Rosie, before you do, the chat room lit up with the fact that you cut out for a moment when distributing the code. And for everybody who's not watching the chat, I just want to repeat that that code was attorney, correct?
Super. It was. Super.
Okay, go ahead with the question.
I hope you can all hear me, because it has cut off a few times. So, in what circumstances can irrevocable trust property be considered for equitable distribution or marital support in New York? I think this is a question for Sean in the first instance.
In the first instance, so when you're talking about a New York irrevocable trust, if you're talking about a trust that was not, first of all, you have to think about who's funding the trust. Is it the spouse's parents or is it the spouse themselves? Theoretically, either way, if it's a fully irrevocable trust in New York, that should be the property of the trust and should not be subject to equitable distribution, with the exception of potentially if the trust was created close to commencement of a divorce action, so it was effectively pre-divorce planning, that would be potentially wasteful dissipation. I'll let Evan speak to that more clearly, but there are cases where there might be claims against that trust with respect to division. A couple of other points. There are cases in New York as well as other states when a party when a spouse in a marriage puts a lot of marital assets in a trust, okay, and then sort of, even if it's not necessarily right before divorce, there's the marital pot is just severely reduced. In equitable distribution, the court can consider a large number of factors, and it is possible that the court could consider the existence of these trusts as a reason to award more marital property, even up to all of the marital property, to the other spouse who did not create the trust. The other interesting thing with trusts is that if a New Yorker was looking to do something funky with, you know, pre-divorce planning, they probably aren't doing it in New York. They're probably setting up a trust that's known as a domestic asset protection trust or a hybrid domestic asset protection trust under the laws of another state, where in those state laws, it would be even harder for a New York court to reach the assets. Conceivably, maybe they could reach the claim wouldn't be necessarily enforceable against the trust. Maybe it could be enforceable against the other assets. We don't actually have great cases on self-settled domestic asset protection trust to truly know the answer, but I think it would be that much more difficult. But again, in those situations, at least with respect to the marital pot, at the very least, I think the court could award all or more of the marital pot to the other spouse. So trusts are, like, I think, such an interesting issue and a really growing issue with respect to divorce that I think really needs to be paid very careful attention to. And, you know, if that's a big issue in the agreement, definitely worth having a T&E and a family lawyer team up.
Evan, have you got anything to add to that in the last 30 seconds?
Yeah, just very briefly, and Sean, you hit it right on the head. You know, it's such a great question. It's interesting, and you know, it brings up the reason, you know, why many people enter into prenuptial agreements, because, you know, this is a hotly contested area in divorce litigation when there is no prenuptial agreement, right? Whether it's an income stream for purposes of support, division of assets, marital property, as you touched on, you know, looking at, you know, lifestyle, looking at, you know, alimony. In the absence of a prenuptial agreement, there will be massive, expensive, lengthy litigation on these issues. And one of the benefits to having a prenuptial agreement is to address these issues so they don't become something that's litigated down the road due to the laws, you know, in New York, both from an estate perspective and also a family law, matrimonial perspective.
Thank you so much, everyone, for attending our session today. Please may you join us in our next session at 9:45 a.m. See you soon. Bye.